welcome back. All those of you sticking it out, thanks very much. I'm going to introduce Sarah Moore now, our next speaker. Sarah needs little introduction to most of you, I'm sure. She's a partner at Leeds, and Leeds certainly doesn't need any further introduction, given how much you've heard about it this afternoon. She spent most of her career at Leeds after training at Freshfields and an interlude as a partner at the global dispute firm Hausfeld. She specialises in product liability and environmental claims against corporations, and there's nothing she doesn't know about the Consumer Protection Act and consumer law, having been had a bruising experience with the metal-on-metal hip litigation. And she's currently leading a large group claim in relation to the some of the outcomes from the AstraZeneca vaccine. So, without further ado, here's Sarah.
Hello, everybody. Thank you for staying. I kind of feel like we've had an interlude and the room's thinned out a little bit, so all of those who've stayed with me, thank you for that. So yes, I'm from Leeds. I was going to ask everybody first, looking at the room, how many people are from defendant firms? Can people raise their hands? Identify yourselves as defendants, okay. And how many people are from sort of claimant firms? The remainder, I suppose, okay. So it's a sort of defendant-dominated audience. And some in between probably as well, which is okay. just wanted to check. I wanted to check because what I'm really going to talk about, despite the heading here, and sorry, Gerard, I'm going to go a bit off topic, is the kind of broader issue of access to justice in the UK, of which this issue of collective redress is a really important part, I think, for reasons I'll come on to explain. But I'm going to start by sort of diagnosing a problem in the UK, which I think, well, I'm hoping that you'll all be familiar with, is that as a claimant lawyer bringing group claims in this jurisdiction, particularly on product liability issues, I think we have a massive access to justice problem. So who would agree with that from the outset? I'm putting my hand up. A few, okay. And there might be a correlation between defendant firms not thinking we have an access to justice problem and those of us on the claimant side thinking we do have an access to justice problem. But I'm going to leave it there for now, and perhaps I can persuade you by the end of this that we do have an access to justice problem, which I'd say is in the interest of all of us to understand, because whether you're on the claimant side or the defendant side, we all use products, we all use medical devices, we want confidence in those medical devices as well. So, right, let's make a start. Oh dear, have I gone backwards? Forwards? There we go. I should also say as well, I was so impressed by the slides from our American colleagues earlier on today as well. I feel like I've barely got a GCSE in terms of PowerPoint, so forgive my very rudimentary slides. Hopefully I can speak to them and at least make it a bit more interesting. So the second thing to say is that we don't have class actions in this jurisdiction, as most of you will already know, I think. When you read in the papers about what's going on in the UK, sort of litigation landscape, you often read journalists talking about class actions being brought. We don't have a class action system, and I think that's really fundamental to understanding the mechanism problem that we have in this jurisdiction, which I'm going to talk about, but which is really the lack of opt-out mechanisms. So now in the EU and in the States and in other jurisdictions, you have the ability to bring a claimant group together and to do it on a representative basis. We don't have that. We have no real workable class action system outside of competition law at the moment. And that is one of the big problems which I think feeds into this overall diagnosis of a lack of access to justice. That's related to this money problem, which is a sort of second symptom of the problem. And then also we have a precedent problem, I think, in terms of the way in which product liability has been interpreted and runs in the UK. So between the mechanism problem, the money problem, and the precedent problem, I think that's what leads me to diagnose this lack of access to justice issue. So first of all, oops.
I think you have to point it direct at the computer.
Oh, look, there we go. The mechanism problem, thank you. So We do, of course, have some systems, some mechanisms through which we can bring group actions. And the discussion just before the break, there was quite a lot of Leigh cases referenced there, and Leigh have this reputation for doing big group actions, both in this jurisdiction and overseas as well, on behalf of claimants against corporations and the government in instances as well. So what we generally use is this thing called a group litigation order, which certainly all the UK lawyers in the room will be familiar with, and that's under CPR 19.21. And then we have this kind of emerging mechanism, which is called a representative action under CPR 19.8. So just to talk about group litigation orders to start off with, it's quite a useful tool. Leigh cases have traditionally been run through that kind of mechanism, as have many other group actions in the UK as well. It's really flexible in that you can take 50 claimants, as we had in Colombia when we sued BP. That was through a group litigation order. When we sued Trafigura in the Ivory Coast, we had 30,000 Ivorian claimants whom we were acting for. We used a GLO there as well. When we did our HIP litigation, I'm looking at Boz at the back of the room, our not quite so successful HIP litigation, we had 300 claimants, and again, a GLO was used. And now the firm Pogus Goodhead are using a GLO for their 200,000 Mariana Dam victims, and the GLOs are also being used in the context of the Dieselgate litigation as well. So we've made the best, I think, with what is a pretty rusty mechanism. But there are some big problems with it, I think, certainly from the claimant perspective, and probably from the defendant perspective as well. It tends to be expensive to run. You have to opt in each individual claimant. You have to put them on a group register. Compare that with the system where you can have a representative claimant and you can run the legal issues through a single claim, and you can have that single claimant as representative of an entire group. There are real economies that can be made by running litigation in that way. But the group litigation order system doesn't work like that at the moment. And as I say, it's pretty clunky. It takes a long time. It certainly eats up a lot of court time. There are significant inefficiencies in that process. So what we in the UK have been quite excited about in the last 2 years is the emergence of CPR 19.8, which is representative actions, which is a bit more similar, I think, to class actions as you have them in the US. The representative actions, I'm told, have been sort of around for hundreds of years, but there's a recent case, this Google and Lloyd, or Lloyd and Google. Google and Lloyd by the time it got to the Supreme Court, but Lloyd and Google further down the court chain, which was a case which probably everybody is familiar with. Does everybody know the case of Lloyd and Google? No? Okay, well, I'm going to give a really potted history. Did anybody work on the case? No, okay, so before I mangle the details, I just wanted to check. But essentially, it's a guy called Mr. Lloyd who tried to bring a claim on behalf of 4 million Apple users for what he said was a breach of the Data Protection Act, because Apple and Google had been using data without Apple phone users' permission, and had been selling that data and using it for commercial purposes. So he tried to bring a Data Protection Act claim. And he said that the putative group that he represented was around 4 million people, and he said that the sort of nominal amount per claim was around £750. So you don't have to be very good at maths to work out 750 times 4 million. There's a huge pot of money. So it was an attempt to use this 19.8 system really for the first time in a number of years. And as a result of that case, we've now got a Supreme Court decision, which has been really helpful in working out how it might be usable. Mr. Lloyd wasn't successful, so the court decided that the case couldn't be run through 19.8. And part of the reason for that was because he hadn't broken down the case into the two parts that now we understand the way in which it should be done, which is that you can have a bifurcated approach. So you can have your substantive issues trial, a bit like a preliminary issues trial for those of us who are used to group litigation orders, where you can deal with the substantive legal issues. And then you can have all the messy individual stuff, like the quantum, the damages, in a second part of the process. But the court found that there were too many diffuse issues, and that Mr. Lloyd couldn't really be representative of all these diffuse issues, and the harm wasn't sort of homogeneous enough across the group to really constitute a 19.8 action. So he failed. I've called it the Goldilocks problem, I should say, in case you're wondering why on earth have I said that. Just because, certainly in claimant lawyer circles, because there are so many advantages to using the 19.8 system in terms of costs and efficiencies, we've been looking for a case that's just right, just like Goldilocks. And we haven't found it yet, as far as I'm aware. But there has been a successful case that has been run through the 19.8 system. Was anybody involved with the Barclays Bank case? No. Again, I can mangle the details of that, hopefully, without anyone picking me up on it. Do go and look it up, just in case I get this wrong. But it's an interesting case, because you'd think that because there's so much energy around claimants wanting to bring collective actions, that you'd hope that the first successful case would be brought by a group of claimants using 19.8. Actually, Barclays Bank were able to use the 19.8 system to their advantage. This is a case where Barclays Bank had introduced a new AI system. Again, we've heard something about AI already this afternoon. And they'd brought this system in, ironically, to try and avoid glitches in the system. And they'd managed, inadvertently, through this AI system, to discharge a load of mortgages for a load of lucky mortgage holders. And then they wanted the money back. Unsurprisingly, I'm not a banking lawyer. You can tell, can't you, by my inexact use of the language. But they wanted to sort of rescind the loans to get the money back in. But it was messy. You know, they got loads of individual mortgage holders, and then all of the chain that went up there as well. So what they did is they decided that they'd use Mr. and Mrs. Terry, poor Mr. and Mrs. Terry, to act as representative defendants. So they applied to use Mr. and Mrs. Terry in their case as 19.8 defendants, and they were successful in doing that. And they were able to run their case, the sort of key legal issues, on that bifurcated basis, that sort of first liability issue basis, through one case. And it was very efficiently done. So we now do have a successful precedent, albeit in claimant lawyer circles it's not quite what we were expecting to be the first sort of case, but it can be done. So I think that's, you know, quite exciting, potentially. And that might be the direction that we start to move into, I think, in terms of group actions and collective redress. But, you know, it's the Cinderella option, isn't it, really? Not to carry on with the fairy tale metaphor too much, but it's the Cinderella option when you look at what's happening in the States and now across the EU as well. You know, there are much better ways to bring group actions, but we just haven't adopted them here. And there are reasons, I think, you know, you could make arguments that that's because we have a sort of more pro-corporate environment. You know, we don't look after claimants here. I'm not going to get into all of that. There's politics around that we perhaps don't need to go into. But hopefully with a new government, there may be some more energy looking at how we can use representative mechanisms better in this jurisdiction. So I've said, you know, if we think about the mechanism problem, what might be different? So if we go through the looking glass and look at how the world might be different on the other side, what we do have in the UK is collective redress for competition claims, as you probably know. And having spent 3 years at Housefeld, which in the UK is mostly an antitrust firm, I can tell you that I had a lot of smug colleagues who could bring together these amazing competition claims for 4 million claimants through a single representative claimant, and could get these cases funded and up and running incredibly efficiently. By contrast, you know, poor me, product liability lawyer, having to go out and book build each case. And I'm going to come on to speak about what I think this kind of asymmetric model that we've got at the moment has done to the legal market in the UK. But at the moment, the only place where we can use those representative actions is in the competition space. What's happening across Europe, again, people are probably familiar with this, but there was the introduction of the Representative Actions Directive, which is now in play. And that has really revolutionised what is happening across Europe. Again, I've got some statistics that I'll come on to, but it's really boosted the markets in the Netherlands and in Portugal in particular. And we've now seen the launching of the first product liability opt-out claim in the Netherlands, which is a breast implant claim, which is being run by Housefeld in the Netherlands, and something I was involved with whilst I was there. And just to sort of give this some more context, whilst we were trying to get a kind of an opt-in group litigation order case together to represent women in the UK with this very specific problem, breast implant problem, and we couldn't get funding and we couldn't get it off the ground. Our colleagues in the Netherlands have been able to opt in 60,000 women who were all implanted this breast implant immediately, instantly. And they are forging they're breaking new ground with this, but you can already see the way in which things are going to move. There is going to be, I think, massive interest and a real growth in product liability in the EU, and we are going to be left behind, I think is the reality at the moment. And that's bad, as I say, for everyone, but I think particularly bad for claimants when they can see their people with exactly the same problems being implanted with exactly the same products, getting access to justice in different jurisdictions. And hopefully that will lead to some pressure for reform, but at the moment, that is not available to us. So that's the mechanism problem. So the next thing I was going to say is about the money problem. So if you can't have these massive groups, you can't do your £750 times 4 million cases, then it's very difficult to build the value in a case. And only when you get the value in a case can you go to a third-party funder, which is how things largely work here, and get them interested in funding your case. So we largely run these group claims on a conditional fee agreement basis where there are personal injuries involved. And it has been really difficult to get the funding that we need to get these things off the ground. It becomes much more attractive where you can do that you can go for a funder and you can do the maths and you can say that there is a lot of value in the case. And you can also say it's not going to cost us that much money to put it together either, because you're looking at the liability issues only. That's what's been happening in the UK, I'd say, for the last, since 2015 really, since the Consumer Rights Act enabled competition lawyers to use representative actions and none of the rest of us. What we've seen is a sort of competition world bubble, I would say, where there has been a lot of investment in CAT claims. And I don't know whether everyone can read the figures on there. They're not my figures, I should say. I've borrowed these from elsewhere. But you can see that there has been a real, there's been a boom in the competition world. And it's now estimated that as of August this year, there was the equivalent of 8.1 actions per person in the UK in terms of single claimant actions filed in the competition courts. So there is no access to justice problem in the competition world. In fact, we're drowning in competition claims. Remember, if you're thinking, how can you be involved in 8.1 actions? These are opt-out actions. So, they've multiplied the markets, they've done the maths, that's how it works out. Whereas, as a product liability lawyer trying to act for claimants in the UK, it is incredibly difficult to get stuff off the ground. So again, there's an asymmetry. Just on the value point as well, so the value of opt-out cases in the UK has apparently jumped by 48%, and opt-out is the competition world I'm talking about. So a massive buoyancy in that market. And we've only seen 1% growth in opt-in cases. So, the statistics talk for themselves, I think. And that's, only in a few years. So the competition world got this ability to use these representative actions in 2015. And over 8 years, we've seen 544, I can't read that. But anyway, thank you very much, Gerard. So the point is made, I think, that we are seeing this imbalance at the moment. And the key factor there is about mechanism. And that leads into this funding question as well. And my lead balloon in black there is that, by contrast, the value of opt-in cases is going down. And I think we are going to see a real downturn in that market. Now, that's not to say that there was some news recently. I was talking with some of my colleagues in the break. There was some news recently on the settlement of some vaginal mesh cases, and well done to the law firm that did that. But reportedly, that was the first successful group action case in the UK for product liability. Now, that's nonsense. It was misreported. I think what was meant to be said, that it was the first successful group action case that had been settled for vaginal mesh, probably, or something like that. What we can say with some authority is that there hasn't been a successful group action case brought through the courts in a product liability claim since 2001. The last successful claim for a claimant group, product liability, was the National Bloods case. So what are we looking at there? Is that like bad lawyering? Is it, or is it a wider systemic problem? I think it's probably a wider systemic problem when we can see that in other jurisdictions, exactly the same corporate defendants are being sued, and yet they're getting results for claimants in a way that we are not here. And I'd say that comes down to this mechanism problem feeding into the money problem. So the precedent problem, as I say, no successful group action for product liability claimants through the courts, and those last three words are really important there, since 2001. And there's really been a failure, I would say, as well, of the CPA 1987 in this jurisdiction. So for those not familiar with product liability here, we do it through the Consumer Protection Act, which is derived from the Product Liability Directive, which our European neighbours and we negotiated back in 1987. It was implemented. Now, our European colleagues in their wisdom have moved on from the CPA 1987, and they're about to introduce a new product liability directive which recognises the fact that it hasn't done what it was supposed to do for claimants across all of these jurisdictions. And there's some very important amendments, not least the fact that under the product liability directive in the EU, they're going to extend the long stop period to 25 years. So at the moment, if you're going to bring a claim in this jurisdiction under the CPA, you have 10 years from the point at which your product leaves the factory gate in order to bring a claim. Now, I've been working on some breast implant cases, and what we found so often is that the women who have approached us are already at the end of that long stop period by the time they get their diagnosis. So that particular cancer takes sort of 7, 8, 9 years to emerge. Products generally sit on the shelves for 6 months to 1 year before they're implanted. So by the time we're getting to the point of diagnosis, these women are timed out. They can't bring a claim against a manufacturer. And you might think, well, that's okay. You can bring a claim against a surgeon or whatever else, or look at different routes. But lots of them want to bring a claim against the manufacturer. And also, not to get too political, but there's a question about who should be paying for this. Should it be the NHS when a product goes wrong, or should it be the manufacturer? I think at the moment we've got a system that actually leans into, I think, privatising profit and publicising or making public, societal, the burden, the liability. And that can't be right. The taxpayer pays when things go wrong, and the companies make a lot of money from the products when they're first launched. And I think that's one of the problems that we have at the moment, and it's systemic. And the EU are fixing it. Now, of course, we're not in the EU anymore, and we can only hope that we get some crumbs from the table and some wisdom is dispersed and we start to have some changes, and maybe the Labour government will do that. But the Law Commission, Rachel will probably know better than me, Professor Mulholland will know, but the Law Commission have been looking at this forever, it feels like. I mean, we had the pandemic, which was fair enough, but it's gone on, and maybe we will see some changes, but I think there are no guarantees at the moment. So this is my prediction. We've got the Representative Action Directive, that's what RAD stands for in the EU. We've got new Product Liability Directive in the EU as well, with this much more generous long stop period and this much more claimant-friendly interpretation of liability. And I think that's going to mean that we're going to have a boom of product liability cases across the EU. And meanwhile, I think there is a risk that product liability in the UK will wither on the vine. And that's, as I say, I think a bad thing for all of us, because whether or not you're a claimant lawyer or a defendant lawyer, we all use products. And I think actually having a workable product liability system and enforcing accountability and transparency in ways that other people have talked about is absolutely integral to making sure that we've got a space in which we can get products to market and give consumers power to do something proactive when things go wrong. And unfortunately, I think things are moving in the wrong direction at the moment. I had another slide, that's why I'm clicking. Oh, I did, okay. So I'm not the only person who thinks that. I'm not alone in my diagnosis of all of this. There was a case, it's actually an American case, so again, I'm feeling that I might be talking out of turn, but there was this American case some time back now, a Leigh case again, which was to do with mesothelioma and Estelle Lauder. And the issue was, in this particular part of the trial, this is a New York judge that was opining, I think, was whether or not this English lady, Mrs. Fletcher, who had used products sometimes in the US, sometimes in the UK, Estee Lauder being an American company, whether or not she could bring her claim in the US rather than having it in the UK, bring it in the UK. And Justice Mendes, whom others might be familiar with, made this really interesting comment, which I think draws out the fact that it's not only us or us claimant lawyers in the UK that have started to have some real doubts about access to justice for claimants in the UK, but it's also perceived in that way internationally as well, and I think that's damaging. You know, you can read the quote here for yourself, but he's basically saying, look, there are no contingency fees. That's not quite true, but we'll give him that. There's no contingency fees. There's no jury trials. I mean, that's something that was talked about earlier. You know, there are no jury trials, and that has a massive impact in terms of the level of damages that are awarded. There is limited discovery. I mean, he's right, there is limited discovery. Out-of-pocket expenses, we definitely have a problem with the way these things are funded, hence the money problem. You know, increasingly we're having to go to third-party funders to get claims funded. And to do that, you have to show that these claims are incredibly valuable. It makes me laugh a little bit where he says, there is product liability law in England. It's good to know, isn't it? All of us who call ourselves product liability lawyers, there is product liability law in England. And there are barristers and solicitors here, apparently, who are doing this stuff. But they're not doing it in the right way, is his diagnosis. And that this poor woman needs help with this claim. And so he ruled that her claim could be brought in the US because the UK was a forum non-conveniens. So I think that's quite a damning diagnosis or sort of viewpoint on the situation here, but it's probably accurate at the moment. So sorry, that's really depressing, isn't it? I mean, we are still doing these cases, I should say, and there's some defendants in the room that will probably be litigating and get against as well. So, you know, we are bringing these cases do settle, but the odds are really stacked against the claimants, I feel, at the moment. And you probably think I'm some sort of rabid Leeds lawyer, foaming at the mouth with my Labour politics and all the rest of it. But I hope that you can at least see the facts on paper, you know, in terms of the imbalances, in terms of the fact that there hasn't been a successful claim through the courts on a group basis. And I think some of those facts speak for themselves. I'm going to shut up, I think. Does anyone have any questions? No. Okay, thank you.
Well, thank you very much.